Welcome, everyone, and thank you for joining us this afternoon at the Federalist Society's presentation on the FCC's authority to promulgate internet traffic rules. The focus of today's panel is the FCC's authority to promulgate net neutrality rules. As you may recall, on October 22nd, 2009, the Commission issued its Notice of Proposed Rulemaking in its Preserving the Open Internet proceeding. The NPRM, in short, suggests moving forward beyond the Commission's 2005 Internet Policy Statement and codifying those four principles, as well as adding two new ones. The first dealing with non-discrimination, and the second dealing with transparency and disclosure of practices by Internet service providers. Comments on the NPRM were due in January, and reply comments are due this Friday, March 5th, so this is a very timely debate. We have three great panelists to discuss these issues. First, we're here from Greg Garre, former Solicitor General of the United States and now a partner at Latham & Watkins. He recently wrote the paper that is the topic of our conversation today, the FCC's Internet Power Surge, the Constitutional and Statutory Limits on the FCC's Authority to Promulgate Net Neutrality Rules. So Greg's going to lead off. Then we'll hear from Gigi Sohn, the president and co-founder of Public Knowledge and one of the most fearless and effective public interest advocates around. And then Helgi will respond. She's a partner at Wiley Rein and the author of the lead brief in the Comcast BitTorrent case, a former colleague of mine at the FCC and one of the greatest legal talents that I know. So we're very excited to have Helgi along as well. And then Gigi will close us off with the affirmative cases after Helgi's discussion, and then we'll open it up to some questions from the audience as well. So be drafting those as we proceed through the discussion this afternoon. So with that, I'll turn it over to Greg.
Thank you all for coming here this afternoon. Thanks for the Federal Society for hosting this. Thanks especially to Gigi and Helgi for agreeing to come here and talk about my paper. By virtue of having done that, I think they may be the only people in the room and maybe in DC who've actually read it, so I appreciate their slogging through it. Also wanted to thank a couple of people who helped me work on the paper, my partner Matt Brill and associate Bill Renner, who did a lot of work on the paper. So the subject of the paper is whether or not the FCC has authority to regulate broadband internet access. And you could think of it in terms of whether or not the FCC has the authority to treat internet service providers like telephone companies. And in 2009, the FCC issued a notice of proposed rulemaking that concluded that it did have authority in this realm and purported to announce certain non-discrimination principles that it wishes to apply to internet traffic. Those principles are subject to a lot of policy debate, important policy debate, which really is beyond the subject of my discussion. What we looked at was the FCC's authority to regulate in this area at all. And when we looked at that, we concluded that the FCC lacks authority. And we started with first principles. And certainly when you live in DC and most people think that administrative agencies can do whatever they want, and usually they do what they want. But in fact, administrative agencies are, of course, creatures of statutes. We have a constitution that places the lawmaking power in the Congress, and it's well settled, of course, that administrative agencies can only exercise jurisdiction and authority that Congress gives it. So the first place you would have to look is what Congress has given the agencies. And importantly, the courts are generally skeptical of agency efforts to expand their authority into new areas. Supreme Court said about a decade or so ago, an agency has no power to correct flaws that it perceives in the statute. It is empowered to administer by extending its rulemaking power beyond the boundaries set by Congress. So what boundaries has Congress set for the FCC? Congress has passed a couple of statutes. Its organic statute, passed in 1934, sets very broad, gives the FCC very broad authority over wire and radio communications. But of course, no specific authority over the internet, since it's not surprising that Congress in 1934 had no idea what the internet was, so it, of course, didn't give the FCC authority over that. Congress amended the statute in important respects in 1996, which is closer in time, although really before the the true advent of the internet as we know it, and it didn't address it there. What Congress did say in 1996 is important, though. It gave the FCC the authority to regulate telecommunication carriers, but not internet information service providers as common carriers under the Telecommunications Act. And importantly, after the 1996 Act, the FCC looked at internet service providers and determined that they should be treated as information service providers and not telecommunications carriers, which meant that they were not subject to regulation as common carriers. And that's important for reasons I'll explain a little bit later. The FCC fought that interpretation all the way to the Supreme Court and prevailed in a case called Brand X. Now, there have been many in Congress who have proposed that Congress give the FCC explicit authority to regulate broadband internet service. Those efforts have not failed. Have not succeeded. They've failed. So the FCC doesn't have any explicit authority that it can point to, but it does have something that the courts have created called the ancillary jurisdiction doctrine, which it can point to and has pointed to as a source of its authority. That doctrine ultimately is rooted in the statutory authority that Congress has given the FCC, but expands it, at least at the margins, to give the FCC slightly broader authority than expressly delegated by Congress. And there are two components to the doctrine. First, the courts look to whether or not the regulation that the FCC is propounded is within the scope of the agency's general grant of authority under Title I over radio and wire communications. That's a really broad grant of authority, and most things do fall within the subject matter of Title I, at least as concerns radio and wire communications. And the internet, it's not really disputed in this area, does do that. The second factor is really sort of where the action is in these cases. And it's whether or not the regulation is reasonably ancillary to the performance of the FCC's statutorily mandated responsibilities. So it's statutorily mandated responsibilities that the FCC has to point to. Ancillary jurisdiction is a pretty good thing if you're an agency because it does expand power beyond the express delegations. It's what the D.C. Circuit has called, aptly, I think, an amorphous jurisdiction doctrine. And because of its amorphous nature, the D.C. Circuit has cautioned that it has to be applied carefully, that the agency can't resort to the ancillary jurisdiction doctrine to give it boundless authority that it can't exercise under our separation of powers. So how does the FCC fare under the ancillary jurisdiction doctrine? And that gets us back to the notice of proposed rulemaking that the FCC passed in 2009 concerning internet access. The notice of proposed rulemaking is about a 100-page document. And if you look at the document, you'll find that about a page of it actually addresses the FCC's authority to embark on this broad new regulatory regime of regulating internet access. And there are three provisions of the Communications Act that the FCC ultimately points to. The first two are Section 230B and 706A. They amount to policy statements by Congress about the internet, in particular policy statements concerning efforts to avoid excessive regulation of the internet. And I think that there are two problems with those policy statements as a basis for ancillary jurisdiction that the FCC is exercising. The first is a policy statement is almost by definition not a statutorily mandated responsibility. It's not a mandate, it's a policy statement. Congress passes lots of policy statements, it's sort of general principles that it thinks are good ideas for agencies or others to pursue, but they're not statutory mandates. Congress knows how to pass a statutory mandate when it wants to, and when it does, it doesn't put it in a policy statement. So that's a problem under the second prong of the ancillary jurisdiction doctrine. The other problem for the FCC is that the content of the policy statements is to promote the, quote, unfettered access to the internet, unfettered by federal and state regulation. That's explicitly what Congress said. So it's a little bit of an odd thing for the FCC to be pointing to these statutory policy statements as a basis for regulating the internet, when the policy that Congress was expressing in these provisions, at least, was to continue with lack of regulation, unfettered access unfettered by federal or state regulation. So I think for those two reasons, I think that these two statutory provisions are a unsound basis for ancillary jurisdiction.